today we're going to talk about kind of taking away some of the mystique of contacting a lawyer. You know, a lot of times when we talk to clients, potential clients, you know, it's their first time ever contacting an attorney and just trying to go through kind of some high points as far as what to expect and to kind of take away some of the stigma of reaching out to an attorney, because people can be intimidated of that.
Welcome to the Law Talk Podcast, where we take you behind the curtains of a successful personal injury law firm. This season, the Hollis Wright team of attorneys will discuss a lot of topics sure to be pertinent to you and your family. You'll hear about current events as well as Alabama legislation impacting the legal industry and you. You'll hear about steps involved in a personal injury case and even hear an exciting case study involving a client, his injuries, and his ultimate success. You'll hear how the work performed by the attorneys at Hollis Wright and in the legal field helps to keep corporate America in check. Before we dive in, a little background. Hollis Wright & Clay is a law firm located in Birmingham, Alabama, with 10 seasoned trial lawyers on staff, a firm built on experience, excellence, and decades of incredible results.
Here with attorney John Spade from the firm Hollis Wright. Good to see you, John.
Good to see you, David.
It's been a minute. I've got to say, you have the finest beard at Hollis Wright.
I will take that title gladly. Thank you.
You may have the only beard. Is there another bearded attorney?
We've got another bearded attorney here, Craig Shirley.
Okay, Craig's a beard guy.
I don't think
That's
he's
right.
been on the podcast yet, but Craig Shirley's got one as well.
Yeah.
Some people call me John and Big John, or Craig and Little
Really?
Craig. Yeah.
They are beard brothers in a way.
That's
Yeah,
right.
the bearded
That's right.
brothers.
In a way. Yeah.
How long have you been at Hollis Wright now?
I've been here ever since I came out of law school. So I guess 9 years.
9
Yeah.
years. Lots changed in 9 years, hasn't it?
It has. Lots changed for the better. Family's gotten bigger over that time.
You have how many children now?
I've got 2. I've got a daughter that is 7, Emmy, and then Jack is 3. So
that household is alive, man.
it is,
7
and right now my wife is up in Nashville, so I'm single dadding it along with everything else and trying to practice law and do podcasts and everything else. So it's been busy, but very, very good.
You're good at juggling. You got to be good at juggling.
That's right.
All right. So what are we going to talk about today? Kind of give us an overview of where we're headed.
Yeah. So today we're going to talk about kind of taking away some of the mystique of contacting a lawyer. You know, a lot of times when we talk to clients, potential clients, you know, it's their first time ever contacting an attorney and just trying to go through kind of some high points as far as what to expect and to kind of take away some of the stigma of reaching out to an attorney, because people can be intimidated of
Absolutely. Yeah. It's. I mean, how often in anyone's life are you going to hire an attorney, right? It's not something you do often. This is your world, but for most folks, it's not. It's kind of the unknown, if you will, and that's scary. So when a new client calls Hollis Wright, what can they or should they expect from that conversation and how that process looks like moving forward?
Absolutely. So when a new client calls, our goal is to try to get them to an attorney as quickly as possible.
Okay.
I think we're a little bit unique in the personal injury kind of space and how we handle personal injury cases. Everybody does it a little bit differently. We're not really set up for a volume and assembly line type approach. There's a lot of firms out there that do that have that manpower, have those kind of structures in place, and it works really well for them. That's just not what we do, okay? Right. It's a little bit more of a one-on-one approach. You're going to be speaking with an attorney. We certainly do have, intake staff that help us, return phone calls and take some incoming calls, but the goal is to try to get everybody to an attorney as quickly as possible, and then have a real conversation, a one-on-one conversation with that attorney, and get an understanding of kind of what has happened, where are they now, kind of meet them where they are, whether that's on the phone or, them coming in the office or us going to them, have a conversation about what's going on, and then give them an understanding kind of generally what to expect. Right. Because like you said, when people are reaching out to us, a lot of times they've never had to contact an attorney at all. And so it's
we don't know how fast this should be or expect it to be or how long this should take.
Right. That's absolutely correct. And every case is different.
Right.
And so it kind of depends on what's going on. I mean, we explained the statute of limitations, obviously, and the most important thing on the front end is to make sure that, the clients are getting the medical treatment that they need and they're doing that stuff, and let us take a lot of the stress, the concern, be it insurance companies, medical bills and creditors are calling, all that sort of stuff. Let's take some of that stress kind of out of the equation so they can focus on, getting better, getting back to 100% so they can, get back to work or get back to their kind of daily life. So
is it an appropriate expectation to know the progress of your case and be able to get in touch with your attorney and have them return your phone call?
Absolutely. And that's another thing that, was instilled in me when I started working here by Josh Wright. It's one of his kind of big staples that he has really ingrained in the law firm is we try to return every phone call within 48 hours. I tell all my staff that as well. Now, stuff comes up, life happens, we still have families outside of practicing law. We take, family vacations. We might be in trial or mediation or depositions or traveling for those things. And so, things happen, but the goal always, and what I tell all my clients is I try to get back to everybody within 48 hours. And sometimes it might be as simple as, hey, look, I haven't heard back from the insurance company yet, or, hey, we're waiting on these medical records to come in before we can take the next step in the process. But having that expectation that you're going to get a return phone call, email, text message, you absolutely should have that going into hiring an attorney because you need to know what's going on with your case.
So what should the expectation be in terms of pay and how much I have to come out of pocket for your help?
Yeah, well, you shouldn't have to come out of pocket anything. And, you see all the commercials, no fee unless we win, all that sort of stuff. That's a contingency fee.
Okay.
And that's how we're set up. All of our cases are handled that way. And that's not unique to us. That's majority of personal injury firms out there handle on a contingency fee. So, it's free unless you win, that type of stuff. There will be a percentage that will come out of the settlement that goes to pay for, my time, my staff's time. We front all the expenses associated with the case. It's really not fair to expect somebody who's gone through a horrible ordeal, who's got medical bills piling up, to then come out of pocket and pay an attorney by the hour when they did absolutely nothing wrong to get here, to be in this situation. And so the contingency fee helps offset those costs and kind of defray some of those costs, and we go and we handle the case. And it's beneficial for the injured party as well because it gives us some skin in the game. And if we're working on a percentage, I'm incentivized to maximize the value of the case, to get a bigger settlement or get a better verdict or whatever it is. And also incentivizes me not to have unnecessary expenses in the case because I know that those are going to come out of the case if we settle it or if we get a verdict or whatever. And so I got to keep that in mind because at the end of the day, we can't undo what was done. Yeah. We can't, change what you've gone through. We can't, make it so that you didn't have to have that surgery or whatever it is. All we can do is try to compensate our clients to put them in, as good of a position as they were before this happened. And so at the end of the day, we're dealing with dollars and cents, and that matters. Yeah. And so that contingency fee is how we're able to do our job, to be able to help as many people as we can. Clients don't have to come out of pocket on the front end, and then we can still get them the compensation that they need.
What types of damages can you expect in a personal injury case? Can you expect to claim?
So, like I said, we're not putting people in jail. Okay, we can't undo what was done. It's all money damages, and there's different forms of that. You've got compensatory damages. Those are kind of what you typically would associate with a personal injury claim. Your pain and suffering, your medical bills, your lost wages. Those are your compensatory. Those are designed to compensate the injured party for what they've gone through. Okay. All right. And depending on the type of conduct or the type of cause of action that you have, you can also recover what are called punitive damages. okay? It's still money damages, but those damages are designed to punish and to deter the same and similar conduct from both the defendant and from the public at large. So, that's where you start hearing, these big verdicts. A lot of times there's a punitive aspect to them. So you've got compensatory, you've got punitive, and they kind of go hand in hand. Sometimes you can claim punitive damages, sometimes you can't. It just depends on the conduct giving rise to the injury.
All right. I like what you said. You're hired. So after the break, what's next? So once you partner up with Hollis Wright, what you can expect. We'll dive into that when we come right back.
Injuries you sustain in an accident don't define who you are, but the firm you choose will. Choose wisely and select a firm with over 20 years of success of winning personal injury cases. Let Hollis Wright tell your comeback story. If you've been injured in an accident, you should never sign with a law firm without first speaking to an attorney at that firm. At Hollis Wright, you'll always speak with an attorney first. Call today and let Hollis Wright tell your comeback story.
Welcome back into the podcast, hanging out with John Spade, attorney here at Hollis Wright. We're in the fantastic offices of Hollis Wright. I do love this space.
Yeah, it's fantastic.
You've been in this space your entirety of your tenure here, right?
That's right. Yeah.
Okay. All right.
Yeah, we've been here for almost like maybe 13 years.
Yeah, very cool office space. A nice old building here on a historic Morris Avenue. So, all right, so you're hired. All right. What do we expect next? Once this lawsuit, kind of where do we go from here?
Absolutely. So in that process, in I guess getting hired, we will try to either have a phone conversation, or if we can, have the client come into the office, come in, here on Morris Avenue, sit down, and we'll talk about the case. And we'll present a, contingency fee agreement. We'll sign that, and then we'll get everything open on our end. So a lot of people, when they think about hiring an attorney, they're thinking, okay, I'm going to hire this attorney, he's going to file a lawsuit tomorrow, and then we're going to be in court in, 3 to 6 months.
Right, yeah.
Okay, that's just not how it happens. For a number of reasons, the most of which is usually, depending on what stage and when we get involved in the case, if an accident happened a week ago, and then you call our office and we, have you come in and we're talking through everything, there's a high likelihood that you're still recovering from everything that you've gone through, right?
Yeah.
Let's say a motor vehicle accident, for instance. The damage to the vehicle is a damage to the vehicle, okay? It's a total loss. It's being repaired at a collision center. That can be over and done with within, weeks, month, however long to get the claim set up, all that sort of stuff. When you're talking about injuries to a person and significant injuries to a person, that takes a lot of time, okay? And so, there's never a rush from me, from our firm, to go and try to get a quick settlement and to try to turn a case, super quick, anything like that. Because before we start that settlement process, there's a lot that goes into that, okay? The first of which is, are you better? Have you been released from the doctors? Have you, recovered as best that you can? Or are you back to 100% or as close to as you're ever going to get? We need to know those things, because once we start the settlement process, there's no unringing that bell.
Right. Yeah.
And so, once we sit down and talk about the case, talk about the contingency fee and kind of a general overview, typically at that point, the client they're in the kind of the treating phase. They're getting better. They're focusing on getting back to work, on getting back to their, kind of daily routine. I'm out there gathering facts, okay? Most of which will come from that initial client meeting, photographs that the client might have taken at the scene, getting a list of their medical providers, that sort of stuff. But I'm talking to witnesses. If there's any video camera footage, I'm trying to secure that. We're kind of in our fact-finding phase and building the case, because, as the injured party, as a plaintiffs, we have the burden of proof. Okay, so we've got to prove that not only the other party was responsible, we got to prove our damages and that they were caused by, the negligence, wantonness of the other party. So we have to build our house. Okay, that's a good way to think of it, and we got to do it brick by brick. And the insurance company, the defense lawyer, they're going to try to tear that house down. So we got to make sure that we've got a good foundation, that's a strongly built house. Yeah. So that's kind of what happens initially is we're gathering all these facts to put them together to kind of build that claim. And, depending on, the facts of the case, depending on what happened as far as liability and that sort of stuff, we'll assess, is there a shot or should we take a chance at maybe trying to resolve the case before we ever file a lawsuit?
Okay.
So just because you hire an attorney, a personal injury attorney, doesn't mean you're locked into a jury trial.
Okay.
Doesn't mean that you're locked into, even having to go through the formal litigation process. Most times lawsuits are filed for one of two reasons. Either there's a disagreement as to who's at fault, or there's a disagreement as to the amount to compensate the injured party. And that's really kind of about it. Sometimes it's both, but that's why people file lawsuits most times. So depending on what happened, if there's no dispute as to liability, maybe we take a run at trying to resolve the case. Yeah. And there's a lot of cases that do resolve before you ever file a lawsuit. But if that breaks down, if there's a disagreement as to who's at fault, there's a disagreement as to the amount of damages, then the next phase would be to file a lawsuit. Yeah. And that, is us drafting, filing a complaint against the defendants, the culpable parties, serving them with a copy of the complaint. They have 30 days after which to file an answer to the complaint. And then we go through the paper discovery process, which is interrogatories, requests for production of documents, requests for admissions. The client is pretty heavily involved in that aspect of it. There's a lot of written questions that the defendants get to ask the plaintiff. Mm-hmm. We're involved in that process, and so that is kind of the paper discovery. And then the next phase is usually kind of fact finding and depositions. Yeah. And that doesn't get as much publicity with Hollywood and everything that comes with a trial. Mm-hmm. This is a little bit more informal setting, kind of like we are here. You sit around, a conference table. You've got a court reporter. Everything's under oath, but the defendants would get a chance to ask the plaintiff questions. Their attorney's there the whole time. Mm-hmm. And so we go through that fact-finding phase where we're taking depositions. We take the defendant's deposition. If there's an employer, we take their employer's, deposition, or a corporate representative of their employer. Any eyewitnesses, that sort of stuff. We go through that factual kind of phase. And then, like I said, we are, we've got the burden. We've got to prove our case. And so, once we get through the kind of the facts of everything, then we go into medical testimony, taking doctors' depositions.
And there's a whole lot to trying a case.
Yeah,
filing the lawsuit. There's a whole lot involved with it.
It is. It's a process, and that's why a lot of times, if there's a chance of getting a resolution, that's fair, mm-hmm. We take a shot at trying to do that before we file a lawsuit.
Go through that whole process,
right?
So we need to take a break. I want to talk about mediation because you often hear that, and what's that about? But also, I have heard and have folks who. There's a problem at work or something happens and you hear the phrase, look, there's no reason to hire an attorney. We can settle this ourselves. I want you to tell me why that's a bad idea. We'll do that. We're going to take this break. More with John Spade, Hollis Wright, after this quick break.
The attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show in 2011, my goal was to do what our firm does best. Help people answer questions related to real-world legal issues they have in their lives in a way that's not intimidating to talk with a lawyer. If the issue is important to you, it's equally important to us, and we're ready to talk with you at no cost.
Yeah, oftentimes people are confronting various legal issues in their lives that really run the gamut of a lot of different legal practice areas such as bankruptcy, criminal law, civil law such as personal injury, divorces, domestic relations. And to be able to have a show once a week that covers those practice areas and answers people's questions in those areas, that's really the main objective of the show.
We use the resources of the many lawyers at our law firm to create a plan that has a lasting impact for each person that calls or texts. And we also give back to the community at the same time. We are here to serve you, the viewer, each week on
the attorneys.
Welcome back. One thing I love about talking to you guys at Hollis Wright, John Spade, is that you help understand. Sometimes you legal folks, you don't really speak English. You use these phrases, okay? See, the great thing in doing the attorney show and this podcast is things just make sense. Another phrase, and I think I have a better idea of what this is, but let's break down mediation, okay? And why, first of all, what it is. Let's just start there, start at the basics.
Yeah.
But also, how does that come into play? And are there times where mediation is recommended? It's the best course of action.
So the answer to your second question is yes, there are times when it's a good idea. There's times when it's not a good idea. And so generally mediation in a nutshell, it is a part of, it is a alternative dispute resolution, a form of alternative dispute resolution, where both sides have the chance to kind of put down their swords a little bit and to explore whether or not, resolving a claim is worthwhile for both sides.
Does it always involve the third party? So like if you've got your lawyer, I've got my lawyer, is it we come together and there's a third party that mediates?
That is the mediator, yes. Okay. And so he or she does not have a dog in the fight, okay?
All right.
They're representing settlement, and that's their whole goal in the whole process, is to be a go-between for, the two parties to try to see if there's kind of common ground that they can settle the case. Mm-hmm. Okay. So they're bouncing back usually between, two conference rooms and, kind of making points to one side, and then they kind of gather some information and go into the other room, and they're kind of making some points and advocating on their behalf a little bit. But it's important for, clients to know that the mediator, isn't really there to push your agenda or to push, the defendant's agenda on you. Their goal is to try to settle the case if they can. It's kind of the mark of a good mediator. Did the case settle or did it not settle? And so it is it's a process. It's all, it's all confidential. So, you go to it with the understanding and kind of the good faith mindset of, we're going to try to get the case settled if we can. And whatever you say in mediation is not going to be then brought up in trial later. Well, I mean, you're asking this jury for, X amount of dollars, but at mediation, you were saying, why? That stuff doesn't ever come up. So it's a process to kind of cut through some of the back and forth a little bit and to explore settlement before going through a trial, because, a trial can, for both sides, bring in some uncertainty. Whereas, if you're able to settle a case, how much it's settled for, you can, kind of have a little bit more control in that process. And it's important to note, we talked a little bit ago about kind of, there's the kind of the pre-suit and post-suit, and why lawsuits get filed. Mediations occur sometimes before lawsuits ever filed. If there's no real dispute as to what happened, right. Maybe y'all are just disputing over the amount of damages. Mm-hmm. We go to pre-suit mediations all the time. A lot of times, though, they occur in the context of kind of in litigation or after a lawsuit is filed. And it's something that really, in my practice has picked up a lot kind of in a post-COVID area, right. Post-COVID landscape. Mm-hmm. I think judges were there's a backlog of cases from COVID. Which a lot of judges were more apt to push mandatory mediations. And so a lot of times it's almost a prerequisite to going to trial. And you'll have a status conference and go in, and one of the first questions when you're asking for a trial setting or, are y'all ready for trial is, well, have y'all mediated the case? Right. What happened? Did the case resolve? Obviously didn't if you're asking for a trial setting. And so that will come up. And so it's almost become kind of a mandatory situation, which honestly has impacted how effectual it is a little bit. And people will kind of go through and you kind of both sides can kind of get a little numb to it. So, we talked about, does it make sense? Does it not make sense? If it's court order, you don't really have a choice. Right. But it's important, and what I typically like to do is to kind of be upfront with the other side and say, look, this is kind of what our expectations are. Yeah. Before we'll just agree to a mediation, I want you to know where we are, and I'll usually send a settlement demand or or give some sort of, background for why I feel the way I do about the value of a case, to make sure that we're not going to go there and waste my client's time, waste my time, waste the mediator's time, waste, the insurance company.